Hello, everyone. This is Mark Holthe. Welcome to Immigration Nation. This is the first episode, if you want to call it that, on the Canadian Immigration Institute YouTube channel. And you can find all of these Immigration Nation videos and live streams that we're doing where I bring on another awesome Canadian immigration lawyer to join me to talk about something that's particularly interesting to them and to me, that's pertinent, that's timely, and to talk about their practice, what they do. Just share with the world everything related to immigration lawyers and why we think every single person out there deserves the right to be represented by an immigration lawyer. So without further ado, let's jump to my guest, David Chalk. David, welcome. How are you?
I'm great, thanks. It's so great to be on with the king of all Canadian immigration media.
Well, I don't know if I'm the king, but I sure try to get some good content out there. And it's sure easy to do it when I have awesome guests like you. And so welcome. I've already got some people tuning in, which is great. They're saying, hey, can I ask a question, sir? They're used to coming on and seeing lawyers. And so those who are tuning in on YouTube, hang tight. Don't ask your questions just yet. Today's topic is going to be focused on Quebec immigration and misrepresentation. And then we'll open it up after for a few questions near the end. So those of you who are connecting in, it's great to have you here. I'm just going to shift gears just a little bit here. And we'll pull in a few people and just let people know that that we are happy that you're joining us live. We've got Jag who says, hello, Mark. Make sure you say hello to David as well here, guys.
Okay. A little hurt, Jag.
You bet. Masi says, can I ask a question, sir? Hold off, Masi. We will connect with you in just a little bit. And so hang tight. So we will get to the questions from the live viewers near the end. But we want to take some time now just to teach you guys a little bit more about some of these issues that just aren't talked about a lot online, or you just can't get this information because it's kind of happening in the background. But before we get to that, let's talk about you, David. So tell us a little bit about your practice. So you're based in Quebec, whereabouts?
Montreal. We're in the historic Little Burgundy area, the cradle, one of the cradle of Canadian jazz, as I like to think of it.
Awesome. I had the pleasure last October of going to Montreal to spend a day with David and to present at one of the Acadie conferences, which is for the Quebec-based immigration lawyers. And David took me around Montreal to these amazing bagel shops and sandwich shops. And I can't remember what they were called, but all I know is that they were the most unbelievably tasting things that I had had. We definitely don't have them in Lethbridge, Alberta. I can tell you that much. So it was great.
Well, that was a lot of fun. I'm glad we could do it. It wasn't fun when we could go do things with people. That was a good time.
Absolutely. And one of the disappointments was that our national conference, like many of you guys who are involved in attending conferences, it was supposed to be in Montreal. And unfortunately, it had to be canceled because of COVID. So that's really why we're even doing this today, right, David, is the fact that we have to be creative.
Exactly.
Excellent. All right. So tell me a little bit more about your practice. And so you're based in Montreal, and you focus on all kinds of immigration, but obviously being in Quebec, Quebec's kind of got its own little deal. So can you tell us a little bit about that?
Well, way back around the time when the Meech Lake Accord and the sort of power sharing arrangements between my province, Quebec, and the federal government were a big topic of discussion. Ultimately, you might remember Meech Lake didn't come to fruition, but we did get a Canada-Quebec Accord on immigration, which provides for power sharing. So the difference between the province of Quebec and all of the PNPs that I'm sure many of your viewers have heard about is that we actually have a law that gives immigration authorities to Quebec, whereas all of the PNPs exist under administrative arrangements. So any person who is coming to Quebec, whether it's as a permanent or in theory, and we can explain that a little bit, as a temporary resident, needs to get some kind of document from the government of Quebec saying that it meets their requirements for that program. Gotcha. And the idea was that because Quebec is a primarily francophone province, it was going to be given some control over who was coming into its territory, and it would be allowed to apply its own criteria. So the important document, I guess, and the one that your viewers are mostly interested in, is a Quebec selection certificate, because a part of an immigration decision is normally selection. That's a decision that the person meets the criteria. And that's why the document is called a selection certificate. That's kind of a letter from the government of Quebec to the government of Canada saying, we'd like you to process the permanent residence for this person. We've already assessed them and found they meet our selection criteria.
Gotcha.
And also for temporary residents, we had this is going to get more confusing now. This is not going to help, because we now call it a temporary selection certificate. It used to be a Quebec acceptance certificate. And that was something that needed to be issued to a lot of people coming in with work permits, particularly if they needed a labor market impact assessment to support their work permit application.
Interesting. So if we can make this a little bit more practical terms for our viewers, let's say I want to sponsor my spouse and I live in Montreal. What is different in that process compared to if I was living in Lethbridge and wanted to sponsor my spouse?
Right. So much room for confusion here, because in the context of a sponsorship, the application is going to begin like all the other sponsorship applications. It will go into a case processing center if it's an in-Canada application in Mississauga, otherwise in Sydney, Nova Scotia. And then only after the file has been opened and the sponsor's been found to meet the requirements to be a sponsor will the person then be asked to go deal with Quebec and have their sponsorship application approved, and the person who they're sponsoring will have to apply for a Quebec selection certificate. Now, the reason that's confusing is because if they were going to come in as an economic immigrant, they would work in the opposite order. They would first have to complete their process with Quebec before they even started with the government of Canada. And just to add an additional layer of complexity, if it was an LMIA application, you would send the two applications out to Quebec and the federal side at the same time. So we've got all three possibilities.
And David has just highlighted why I do not touch this stuff with a 10-foot pole. I refer it to him, and I refer it to colleagues in Quebec. Because when anything Quebec-based, it's just all these little nuances. If you don't understand how this works, things can fall apart. So let's bring up one of the most important distinguishing issues, I guess you could say, with economic immigration. It's express entry. So David, if I live in Montreal, will express entry work for me?
Actually, I hope you'll let me give you a two-part answer.
Please do.
Actually, maybe we'll come back to the second part later. But the answer is basically no. If you're planning to live in the province of Quebec, you cannot go through express entry. You would have to first apply for that Quebec selection certificate. And as the crow flies today, the processing time for that application is supposed to be 6 months. Gee, that sounds just like express entry. But it's not that easy. Because after you've got your selection certificate, you send a paper application to Sydney, Nova Scotia for permanent residence. And there it will sit and accumulate dust as things stand for a considerable period of time. And if things continue as they were before COVID, it would be a little under 2 years before you got permanent residence. Wow. And with the fact that the government's not meeting its levels and that a lot of those files continue to gather dust in Sydney, we are not, it's not unlikely that the processing time could increase.
Wow. And there was a time, David, before the current regime in Quebec when Quebec was the bomb. Like, things were awesome. Processing times were really, really quick compared to the federal side. And it's amazing how whoever's in power has a direct influence on immigration processing. So it'll be interesting to see how this all plays out.
Absolutely. Hopefully, the people in Quebec City will look at that processing time as a problem that they can solve. And I think they have tools that they could use to significantly improve the situation. And we hope to convince them that they should do that.
Well, hey, that's why we're doing these live videos too. So excellent. All right. So I guess before we drift away from the Quebec processes, and I think people have a general idea now of the differences. Obviously, we've just scratched the surface, so make sure I'll put David's contact information in there. If you're looking for an immigration lawyer, and you've got Quebec-based options you're considering, David is where you're going to go. Now, David, are there any takeaways for people who do say, you know what, I'm in Quebec, I'm working for a company, they're turning this over to me to kind of do myself. I will always advise them to use you, but if someone's kind of a DIYer at heart, Are there certain aspects of the process, and now we're talking big picture stuff, that they really should not forget to do, or common mistakes that people make that cause them to completely fall apart? And that's pretty
Yeah,
open.
there are a couple. One of the most common causes of problems is that the government of Quebec's people who deal with these files are real box tickers, and they are sticklers for getting all the documents that are on their document lists and getting them in the exact format that they're required. And that's something that requires a lot of attention. And I mean, I just had an email yesterday from somebody who had responded to one of these, sent in documents and said, we want to hire you. We don't understand. We sent them what they asked for, and they're still not happy. And actually, they didn't send them what they asked for. They just didn't realize it. So it's really important to pay all attention to all the details on those document lists, and get all the documents and the format, exact format that is required. And if you can't give something in the exact format, give as detailed a letter of explanation as you can, and prove that you can't get the document in the format that it's required if necessary, because there is very little slack on their end.
Yeah, and in that sense, David, this is almost identical to, the express entry processing, even most of IRCC processing these days. They have a
Right.
great tendency to just return the whole thing versus sending out a letter of request asking for one little piece of information that maybe you hadn't provided. So, on the surface, it looks like everything is super transparent. It's easy to understand. Hey, they even give you a nice document checklist with explanations, but it never covers off every situation. And the moment you miss one little thing, and I keep flipping back on the federal side to the consequences with express entry, and people can miss one little thing. I just had a request today for a client who wanted to hire me, who I'd had a consult with about 2 months ago. And I said, are you sure you don't want me to review things before you submit it? Oh no, I've got it. I've watched you online. I've watched the videos. And lo and behold, it got returned for one little simple thing that he should have realized, but he didn't. And he just about was at a stage where his opportunities of immigrating were gone forever. But fortunately, there's still time to save it. But that's the exact same thing for Quebec, I'm assuming, as well.
Well, actually, one nice thing about the province of Quebec, and it would make people like you nostalgic for the old federal system, is rather than sort of just giving you one kick at the can, if you do have a mistake, they normally will send you something that's actually a little more frightening than what it's called. It's an intention to reject or refuse letter, and they're saying that, we are intending to, you haven't given us a complete file. We're intending to refuse or reject your file. You have X days to respond.
Mm-hmm.
And you actually also have an administrative review process if your application is refused. So your only recourse isn't necessarily to federal court if you don't think you got the right decision.
Well, that's great.
So there are some nice things. And actually, one other thing, it's important, I think, that I should mention. One benefit, the one benefit that the government of Quebec has been talking up of our Quebec Experience program, which in a lot of ways is like the Canadian Experience program in that, and it's become more like that. It used to require, and actually until today still does require, you to either have a year of work experience in the province, and under the current version of the program, that could be at any skill level. In the new version coming next year, it would have to be 2 years at level B or higher, or in some limited circumstances, if you had relevant training in level C, or just have finished your course, your post-secondary course of a certain length. Usually it's about a 3-year course that they're looking at. And if you did that and you could show that you had French, English is not an option in Quebec.
Yes.
You had an advanced intermediate level of French, you qualified. And the remaining advantage in either the old or the new version of this program, and the new one, again, more restrictive than the old, because even students are going to have to work as well after the completion of their studies, as for the CEC. The beauty of it is that you are not going into a pool. You qualify. You can fill out a form and make an application the way we used to do it federally before 2015. You have the certainty of being able to make an application. That's something that you don't have with CEC at the present.
Right. Well, there you have it. So there are definitely some advantages. And I think some of you who don't even consider Quebec as an option, this may open your eyes a little bit. Now, obviously, when it comes to Quebec, any type of Quebec immigration, it's going to be a whole lot easier. And maybe the options are very, very limited to start with for anyone that is, an Anglophone who does not speak French. But if you have you come from a country, and you're looking to immigrate, or you're currently in Quebec right now, obviously French language ability drives the ship, right, David?
Well, yes and no, and that's actually one of the great myths sometimes around Quebec immigration is that French is always a requirement, and it's not.
Yeah.
It's certainly it is absolutely a requirement in all cases for the Quebec Experience Program, but Quebec also has a skilled worker program for which it's not a requirement. It does eat up a lot of points, and it is much more difficult to qualify without any French. But it is possible, and in the business programs as well, it is possible to qualify without a level of fluency in French. But yeah, certainly if you speak French, that is going to be a huge asset to any kind of immigration program here in the province of Quebec.
Perfect. All right. Well, thank you, David. That was super, super helpful. Now, today, there's a couple different things that we wanted to talk about. Obviously, one was this difference between the Quebec immigration process and the federal program for all the other provinces. And David's done a great job of explaining that to us. We also wanted to talk about something a little bit more controversial. And I think this is always the fun part with us immigration lawyers. We love to figure out what's going on in the background. This is really what makes us different. We really want to understand what is driving the decision making on the other side. And some of the trends that we've recently seen is a propensity from immigration to refuse applications for misrepresentation. And many of you express entry candidates or people who have gone through the process see all of the horror stories all over the place in that context where you have forgotten to disclose a visa refusal from a different country. In particular, often it's the US or the UK or Australia, New Zealand, where Canada has information sharing agreements, but you've forgotten to disclose that in the context of your express entry background information section. And then you get this nice little letter from immigration saying you are barred from Canada for 5 years because you didn't disclose that prior refusal, which is cruel and heartless. And we're starting to see more of it, I think, aren't we, David?
Yes, we are. And apparently that's by design. That was what we just found out.
Yes. And one of the context in particular, those of you who are in India right now, and one of the trends that we're starting to see is more and more people who are starting to submit what we call C41 and C42 applications. And I am going to shift over here and just share my screen and the website. And David, I've dropped you off just for a second here, but this is what we're talking about. One of the programs that has really come under the gun and the sights of immigration where they're using misrepresentation very, very liberally. So they're applying it quite frequently. And the programs are the spousal open work permits. If you're coming to work as a skilled worker or to study, we call them C41, C42. This is an application that's submitted for you to accompany your spouse to Canada who are intending to work in a skilled occupation or study on a study permit. There's a program that allows you to come and obtain an open work permit. And so through an access to information request from our good friend Richard Kurland, we now receive some information showing that there is a deliberate intention to use a finding of misrepresentation where they're questioning the genuineness of the relationship. And it is like a sledgehammer to people who are trying to apply through these programs. So I'm going to shift back here and pull David back in. And so David, when we're talking about these processes and in particular how immigration is using misrep, what are your thoughts on this?
Well, I think this particular situation has played out like other situations we've seen in the past. I think IRCC caught on to something that was real and that was concerning. They were noticing that they were getting a big increase in the number of the spouses applying to go to Canada with another work permit holder. And these were almost all men. And they have had issues in India with spousal fraud in the past. and they started to suspect that that might be what was going on there, and they started to do some interviews, and the interviews seemed to confirm that yes, they were onto something genuine. Now, this is where things, in my opinion, took a turn in the wrong direction. So the response to that was to create a quota for an annual quota for misrepresentation determinations for India. And it wasn't specifically linked to C41 and C42 applications. It was an overall quota. And what's happened is it spilled over into all kinds of other things. And just to tell a story, I don't know, Mark, was it in 2014 or 2015 we did the CBA conference in Calgary? I think it was 2014.
I think it was, yeah.
And it happened just by strange coincidence. My flight to Calgary had me seated next to an RCMP officer who was going, I think, to do the formalities for his retirement, and who had worked in some immigration stuff. And we had a super interesting chat because our video monitors weren't working on Air Canada. So we had nothing to do but talk to each other the whole way. And we were coming off at that point a period when we had seen some really brutal enforcement action here in Montreal. Relating to citizenship fraud. People might remember or might not that in 2012, I think it was, then Minister Kenney, came out very strongly and said that Canadian citizenship is not for sale. And it's clear that the word was passed to the borders, particularly here in Montreal, that they were going to be tough. And it's okay to be tough. But the problem was that that the immigration authorities here had known for many years that this fraud was going on. They had done nothing about it, and they had really given people the impression legitimately that they didn't care about it. And now they decided they were going to care about it, and women and children, children were watching their parents be handcuffed. Women were being put in, a 9 months pregnant woman was put in jail, separated from her mother and small daughter. I mean, really bad things happened that were totally out of proportion, I think, to the level of the immigration sin. So what I think we're seeing, and my concern, to come back to my conversation with the RCMP officer, is, I have the impression that the people, when they do these things, the people who get nailed are not the worst offenders. It's not the big fish. It's the low-hanging fruit. And that, I think, is what we're seeing. So if an officer sees that a person has not disclosed a past conviction, not a conviction, excuse me, a past refusal for a visa in another country, there is a much bigger risk right now, I think, that officer is going to throw the book at that applicant and ban them from Canada for 5 years than might have been in the case if they weren't trying to meet some sort of quota.
Yeah, I agree. And that's the hard part. Anytime, there's this impetus. And think of it also in the context, a similar world, I think, is the old minister's permit or the temporary resident permits and the issuance of those. And there was a time on the borders when they were really pushing to restrict and to reduce the number of TRPs. And I remember even when I worked on the border in the old minister's permit days, when these artificial caps or artificial quotas are put on these types of things, it starts to distort the actual adjudication process, and it starts to infringe on administrative law principles, and that's where, I guess, as lawyers, that's where we fit in, right? If we're
and maybe we need to explain that misrepresentation in Canadian immigration law is a very blunt instrument. It doesn't require any ill intent. It could have been an honest oversight by the person, and it may be that the thing they forgot really isn't all that big a deal, but it does, according to our law, then put them in a position where they can be banned from Canada for 5 years. I think if an officer has more things to think about than whether this is an appropriate case in which to apply that very strong sanction, then we have a problem. And I think that the federal court and our immigration department are going in opposite directions right now. The federal court has been putting out decisions in the last couple of years in particular, saying they really want the officers to respect what they call the participative rights of the applicants, to make sure that where there's a situation where they could be banned for 5 years, that they understand what it is that they're being accused of doing, and that they have a chance to respond to that. And that response can not only be, I didn't do the thing that you said I'm doing, or what you have in your file isn't correct, must be another person with my name or something like that. It can also be, you're right, I did that, but I'd like you to consider the rest of my situation and how I made this mistake, or why I said this thing that isn't true, or didn't say this thing that is true, and why you should nevertheless give me the visa, or at least not ban me for 5 years. So they're supposed to have that opportunity. I saw a procedural fairness letter last week where the letter said to the applicant, literally, this was the entire extent of the relevant part of the letter, I believe that you have provided false information about your husband, period.
Yeah, that's it.
How the person, and in that case, actually, the person tried to guess what it was that the officer was concerned about and guessed wrong. Yeah. It was something completely different. They probably never could have guessed. Yeah. And that's not how the system's supposed to work.
And that's a good point, David. So when you are a client, and obviously anyone who's watching this, or an individual applicant, and you face one of these procedural fairness letters, or even get a finding of misrep, what options do they have?
Well, I'm the last person to push lawyer services on people who don't need them. But if you've got a procedural fairness letter, it's probably time to talk to a lawyer. Yeah. That's the first thing. But the second thing you need to know is the wrong thing to do is do what I just said, is to try to guess what it is that the officer thinks you have misrepresented in your file. Never, never, never do that. You need to write back. You need to say, I need clarity on this. If there's a source, I don't know what your source is for this wrong information you seem to have about me. Tell me what information you have and where you got it from, and I'll be happy to answer all your questions. And by the way, give me a little more time, because I'll need that to take it into account the time that we're spending for me to ask these questions and you to give me the answers.
Exactly. And sometimes people don't realize that they can follow up that procedural fairness letter with a request for more information, because it's impossible, as David has identified here, for you to guess what the issue is. And, sometimes in the context of express entry, some of the questions that are asked are not very clear. And especially in the background information section, and any other country is kind of tacked on at the back of those questions. If you don't read them carefully, sometimes people think, well, they're just asking if I was ever refused a visa to Canada. And they're totally caught unaware because they didn't read the details. And some people are more detail oriented than others. And then in some cases, like David gave the example of a spouse where they said, well, we just don't believe your relationship is genuine, or you've provided some information that isn't true related to your spouse. Well, it's completely unfair for them to tell you that and then theoretically give you an opportunity to respond, but you have no clue what the case really is that you have to meet and what what the issue is. So don't be afraid to follow up and to request it. Now, this is where I'm going to jump on my soapbox a little bit, David, because I recently read a little excerpt from a respected consultant who is advising all of the other consultants not to hire lawyers ever, unless they are a friend of consultants, or always refer them to more senior consultants instead of going to a lawyer, because we're trying to shut the consultants down. And I didn't want to get into this topic, but clearly we have no desire to shut all consultants down. But this is a huge issue if you have a consultant who's counseled you to misrepresent. Now, there are excellent consultants out there, but there's some really crooked, shoddy ones. And if you're in a situation where you've been advised, whether you felt coerced into do it or you were complicit, but you felt like you needed to say something or fail to say something in an application because you thought it would increase your chances of success, and then that consultant is telling you, oh, don't go to a lawyer, don't, just let it go because it'll make your problems worse. Do not listen to that. If you're in this situation when it comes to misrepresentation, absolutely, a consultant is not going to help you in federal court. Only a lawyer can take this action forward to federal court. And there are some wonderful lawyers.
If I could jump in, Mark,
Please,
even
David.
Before that, I mean, the elements, understanding, well, what is misrepresentation and what isn't, is something that requires, I think, some sort of legal background. I'm not saying that a consultant can't understand it, but you're more likely to get, I think, a good opinion from somebody who does have that training.
Yeah. Yeah. And at the end of the day, my biggest concern is always you. It's all of those people that are watching this, who are out there in the world, who really don't understand. And this is one area where you do not want to mess around. I just had a heartbreaking call with a client just yesterday where she, David, in the context of her ETA, had allegedly misrepresented something. And she hadn't. It's just how she answered the question. The officer twisted it and then sent her that ETA. He sent her that bar for 5 years and said, we're refusing your ETA and for misrepresentation. And unfortunately, she didn't reach out to me for months after, and there was very little we could do at that stage. So this is something you cannot sit on. You can't wait. You need to take action immediately. If you get one of these, the procedural fairness letters, or even if you actually receive the negative finding, that's when you need to reach out to a lawyer like David immediately, or someone within my firm, and we can help you. And that's why we do this, right? This is why I created Immigration Nation, was to help people understand some of these things that are just not readily apparent. Yeah.
I think there's also a misconception and a reluctance on people's part to go to federal court for a couple of reasons that I'd just like to say a couple things about.
Please.
I've heard it often expressed that, oh, I don't want to go because it'll make them mad at me.
Yeah.
And I've never had that happen.
No.
What I have had happen is I have found that if you stand up for your rights and assert them properly and professionally, you'll get respect, and you'll probably get treated better than you would have if you just allowed someone to sort of walk all over you. And the other thing is, there is a misperception, I think, that immigration litigation is always super expensive. And to be honest, sometimes it is. I mean, sometimes it's complicated and it involves lots of work, lots of hours, transcripts. You know, there are expenses. It can be expensive. But when you're talking about a misrepresentation case, sometimes it may be a fairly simple fact pattern, and it may be a straightforward set of legal pleadings, and it's not super expensive. And it's certainly, in my mind anyway, for many people, money well invested given the payoff.
Well, considering the consequence of not doing anything, right? So you let it go, you're barred for 5 years. And, you know, and the biggest thing people don't realize, it's not just a simple matter of, okay, I have to hold off on coming to Canada for 5 years. Trust me, that finding is going to haunt you long into the future. And even when you then try to apply for any other immigration application, right, it's going to be a factor in that processing of that, of that future application. So,
and other countries even, because the countries tend to ask, have you ever been, banned, from a country or refused an application, and explain. And you don't really want to do that.
Absolutely. And these types of findings are very damning. To have an allegation that you lied or misrepresented in some way on your application, then it goes to your character. It goes to whether or not a future application, like David said, in Canada or in any other country, is whether they're going to give you the benefit of the doubt or just assume that you're not telling the truth on this current application. So I think we've covered that in quite a good depth. David, you did have one story that I wanted to ask you about. And sometimes these practical examples really help to illustrate the points that we're trying to teach here. And this is really about education. It's not so much about telling the world David Chalk is an awesome immigration lawyer, because he can't say it himself, but I can. That I think he's awesome, and he would be able to help anyone who had any immigration, whether it was Quebec or outside of, throughout the country. But what this is about is educating people and teaching them and helping them to avoid these common problems that arise. And sometimes seeing what can really happen to real people and real experiences is very illustrative and can help us to avoid similar things. So David, you got a little bit of a story to share, and
kind of a tragedy, yeah.
Yeah, a sad one. So take it away.
Well, in about 2011, I started to get involved in a whole group of cases. In the end, it was 10 that got into federal court. And they all basically had the same story. And I spoke to all these people at one point or another, so I can confirm that, live to me, they confirmed the same story. They were residents of the city of Isfahan in Iran, second largest city in the country, and they were really, in some ways, the creme de la creme of the city. We had a really impressive group. We had bank managers, dentists, architects, computer science professors. I think I literally had a brain surgeon in the group. Just, really wonderful future immigrants for Canada, in my opinion. And they made a mistake. The mistake they made was understandable, but it was a mistake. They hired a guy who had been doing business in Isfahan for a number of years, and apparently had success for some clients, to do their skilled worker applications to Canada. And the guy, at a time when recently consultants had started to be required to be licensed, was not licensed. And he submitted all their applications. The ones I saw were submitted between 2004 and I think early 2006. And at that time, Iranian applications were going to the office in Damascus. So what they were all told is, don't worry about English test results. You can write the test later. What's going to happen, and the story varied a little bit, but was basically later on in the process, they're going to ask for an update, and they're going to ask you for your English test results, and you'll submit it then. Some of them didn't wait that long. One of them submitted her test results 6 weeks after submitting the application. But and that woman, I think, in the end, submitted 3 different sets of test transcripts, all showing her with a result that would have qualified her as a federal skilled worker. But what these people didn't know is that the consultant was submitting their applications, each and every one, with something that looked like an IELTS language test transcript, but was not. It actually even said on it that it wasn't. This is not a test result in the form of a test result. And things got hairy, I guess, in Syria, and they got overloaded, and they moved a lot of the files for Iran over to Poland in Warsaw. And at that point, these people started to get exactly the request that they heard they were going to get. They were asked to basically resubmit all their forms and many, many documents and language test results. So they sent them in if they hadn't already done it. And after that, they started to get these procedural fairness letters, basically telling them, even though by the time they got these letters, every one of them had submitted a genuine IELTS test result that qualified them for as a skilled worker, saying you submitted earlier on this document that is not genuine. And we had a lot of these cases, and we pulled out every legal argument we could, including, I guess, the obvious one, which is kind of an agency argument, which is that we never told this guy that he could submit fake documents for us. We never knew anything about it, which was true. Unfortunately, he also got them to sign blank forms, which he later ticked to say that they were submitting language test results with them, and that was the misrepresentation. By the way, we should have won, I think, in federal court, but I won't bore your audience with why I disagree with the decision. But we got the decision we got, and we lost. So even though, I mean, my argument at one point to the judge was, would you have my clients literally walk with their consultant to the courier or the embassy or the consulate to submit their application to make sure he didn't slip in a bogus document? That argument did not prevail because there's no requirement in our law that the person had any intention to do anything wrong. And the main message that the judge was hoping that the world would get, and I'm telling you, world today, the message is you live and die with your representative. So if your representative does something that they shouldn't have done, even if you didn't know about it, although there are now some limits in the jurisprudence to that, not knowing about it, if you weren't negligent, maybe you can get off the hook. But there was a case where a consultant had filled in an ETA application saying the person had no criminal, had no visa refusals, whereas the person did, and the person, when they did their own applications, had admitted this, and the court said that they shouldn't bear the burden for the unauthorized. The person never even authorized the consultant to make the ETA application. So there are some narrow exceptions. You don't want to be worrying about the narrow exception.
No.
You would like to have your application submitted competently and properly and without fake documents. Yep. And as I said, the message to the world from our federal court is, if you hire somebody you shouldn't, and even if you don't know that that's the case, you will bear the burden. By the way, I should mention that about 5 years after these applications were submitted, CIC did go back to the applicants and said, hey, you have an unauthorized representative. So they changed that. But they still didn't know, because they didn't do access to information requests. They still didn't know anything about this document that had been submitted earlier.
And I can only imagine how frustrating it was for them, because, like you said, these are professional, educated people who had no reason to question or doubt. The mistake they made was who they hired, and in the end, like I said, it took how long, how many years before they realized or were actually told what was the problem. And
Right. And our federal court decisions came out in 2012.
yeah,
So this was, 6 to 8 years after those
yeah,
applications were originally submitted.
yeah,
And my guess, I don't know this for a fact, my guess is the only reason that the consultant put in these bogus documents was he didn't want to lose the client, tell the client, you got to take the test and come back. Maybe the client would go to someone else in the meantime. So to keep the client sort of on the hook, keep them working with him, and to have a complete application, he sent it in with those documents.
Now, David, here's the question of all questions. What became of this bogus consultant?
The bogus consultant lives in Montreal. As far as I know, not much. May not be able to go back to Iran because I know at least one of the clients in Iran had filed a complaint for fraud against him in Iran. But because was not a member of a professional organization, didn't suffer any professional sanction, and because nobody filed a criminal case against him here, he basically skated. I don't think he's gone back to the immigration business. I think he maybe learned a lesson in there somewhere.
Mm-hmm. Yeah.
But really didn't have to refund money as far as I know. Yeah. Really didn't have to face the music in terms of the thing he had done. And I think that in the end, Canada lost on the deal too. We had a group of really terrific people who wanted to come to our country and help make it a better place and contribute to the labor force.
Yeah, and that's what I was going to ask you, David. For every one of these people who innocently, or innocent, I don't know whether it was innocent or not, like they should have known that the person could represent them. I'm assuming, have any of them that you're aware of been able to find another way to come to Canada, or is their dream done?
No, and that's not a big surprise because in the years that went by, they lost points for age. And they were sickened. Honestly, they had lost. By the time this thing was done, I don't think very many of them were that interested in coming to Canada.
Yeah, and you can see. So, if we were to look at this situation, the one piece of advice I would give, and I'm not here because I know the consultants will be all over me, and that's fine. I don't want to disparage. There are some wonderful consultants out there that do a great job. And like David said, where there's lots of choice out there. But when you make your choice, do not just trust that representative, no matter who they are, to submit your application without you looking at it in detail and having an ability to vet it. Now, that'll only go so far, as David indicated. You can't, once you've signed the forms and you've vetted everything, the only extra thing or step that I would advise is make sure you have a copy of everything that they've submitted. So you request that. And but don't just sign blank forms. Don't just fill in questionnaires and let them submit, especially in express entry where there are no signatures required. Force your representative to provide screenshots. If these representatives are kind of twisting things and using your own Mycic Portal, make sure you have control over it. You've got the login, you've got the passport, because as David's indicated, the buck stops with you. And if something happens and it's not done properly, it's not gonna fall back on that representative. Very rarely will it. It'll be you who will lose your opportunity to immigrate to Canada forever. So I can be a fearmonger with respect to this issue because I've seen it happen so often.
Maybe not forever, but 5 years, and it'll be harder after the 5 years also. But yeah, these are really unfortunate situations, and sometimes, it's important to get a good opinion. It doesn't cost that much to find out whether what's going on is happening the proper way, whether under Canadian law you're really subject to that sanction, what are your recourses to get out of it, because there is in many situations at least some discretion that will allow you to get around it, particularly if you didn't have bad intentions. Yeah.
And I'll just reemphasize something that David just said. $200 is what I charge for a 25-minute consult. I'm positive David isn't much more than that for a consultation. And in that short period of time, we can let you know if you're on the right track or if you're not. If you have these questions that are just borderline and your consultant's telling you one thing or your representative saying one thing and you just have doubts, 30%, David, of my consultations are with individuals that have used a consultant or are currently using them and want a second opinion, or they have had huge problems. Applications have been refused because of just not using a representative that they can trust. So that's the one shout out I would give to people, is that there are locations you can trust. And Obviously, David, you know how the Law Society and your Law Society treats any any lawyer who gives bad advice or counsels misrepresentation or anything like that. My goodness, our ability to practice law is on the line. So, we've got a hammer waiting over us if we've if we are, doing anything untoward.
If you just give me a minute to weave the two threads of today's
Please
presentation together, actually, one of the common procedural fairness letters that we're seeing these days in Quebec relates to express entry. It's for people who have applied into express entry but are living in the province of Quebec. Often they have studied here and then sometimes after studying got a job here. And it's important for people to know, first of all, that that's not a joke. If you apply into express entry, you can not only have your application refused, but you can be sanctioned with 5-year ban from Canada if it's determined that you lied about your intention to live outside Quebec. But also there are things you can do, and also that the law in Canada, and this is poorly understood even among visa officers and immigration officers, it doesn't require the person to actually leave the province of Quebec before they become a permanent resident or even on the day they become a permanent resident. We have one federal court decision on this. It's a wonderful decision by Justice Diner called Dhaliwal. And Justice Diner is pretty clear that so long as you intend to leave the province, have credible evidence of an intent to leave the province within, let's say, 2 or even 3 years after becoming a permanent resident, you're on all fours with the requirements of the law.
Absolutely. And we see this a lot with the McGill programs, right? And so students that are there, and that's a lot of the case all that we've seen stems from students there who now are looking to apply for permanent residence.
Mrs. Dr. Dhaliwal was a PhD candidate in engineering at McGill. Exactly.
Yeah, exactly. So this is great. Thank you so much, David. Okay, well, let's take a few minutes and I'll pop up some questions here, and some of them are quite interesting. And so let me just shift over to a little bit of a better screen and let me pull up some questions here. So if you have a question that relates to what we've been talking about today, those are the ones that we're going to hit on. Remember, my live Q&As are open season. We talk about everything. But these ones are really geared to be directed to David and me as well. But really to David, give him a chance to show you guys provide some clarification regarding the topics we've talked about today, which are Quebec immigration and this whole concept of misrep. So the first question we have from Noah here says, Quebec's immigration system seems more difficult and complex. That's why a whole lot of people seem uninterested. Not necessarily the French language barrier. I'm bilingual, for example. So what do you think about that, David? Is it a fair statement that it's more difficult or more complex, or is that just a misconception?
I would go along with Noah where our skilled worker program generally is gone, because we don't even know. Government hasn't even announced what they're going to do with it. They're going to do something along the lines of EE at some unspecified point in the future using some unspecified selection criteria. So to say it's difficult to understand, I would say yes, it's impossible to understand unless you have a functioning crystal ball. But the Quebec Experience Program, on the other hand, is pretty straightforward. So those who are studying here or working here, and who can put up with that long time to get permanent residence, I think that's an excellent program. And again, we should not minimize how important that security in knowing that, okay, when I've done these things, I'm going to qualify for permanent residence. I don't have to outrank a bunch of other people in the pool on scores in an uncertain scenario in the future. That's a serious benefit.
Awesome. Okay, so there you go, Noah. There's clearly there's room for interpretation in terms of that. Okay, I'm going to pull this one up, David. This one is a little bit more generic. It's from Katie, and I'm not sure if if you're in a position to be able to answer this. If not, this is not one that I usually deal with. But she says, is it also misrep if someone who is now a refugee claimant in Canada, her country of origin messed up, I think is what she's trying to say, messed up her name on her passport and left the surname space blank, and IRB has it now?
I mean, there actually are special rules, which I don't know if it's within the scope of our show today to go into, about misrepresentation in the refugee context, and which are usually favorable to the refugee claimants. But I haven't seen that exact situation. I couldn't say. I mean, if the person was honest in their declarations, well, my passport says this, but I've also used this other longer name. I have difficulty seeing that that would normally be a problem.
Yeah, yeah, I agree. Especially when you're not, you're not misrepresenting something. Like we have a lot of countries, aside from that, where individuals have passports that are issued with errors. I see a number of them in India, even where sometimes the person only has one name that's actually on the passport, or both
Right.
names are just in one line. There's no first name or surname, and so it's only in situations, at least my position, where you have the document itself is fraudulent. That hasn't been an issue where there's been just a clerical mistake that can be corrected by showing a birth certificate and where the mistake occurred. But you definitely want to catch it as early as possible, and you want to identify it as early as possible in the process, and then take steps
Right.
that you can, if possible, to correct it. Now, obviously, as a refugee claimant, it's not always easy to go back and to the source country of your claim and try to correct civil status documents. But
It'd be a very bad idea to apply for a new passport after making a refugee claim.
absolutely. So disclosure, those explanations are really, really important. Okay, this is an interesting one. This is from Jag. And so I'd also encourage you guys to reach out to David, and I'll provide the consult information. But he says, that is the reason I made appointment with you, I think, for Monday. Too many shady consultants out there. Now, once again,
Jag, you hurt my feelings at the beginning, and now you've redeemed yourself.
exactly. So the reality is, as I've said this repeatedly, because the whole purpose of this Immigration Nation is to highlight the benefits of hiring an immigration lawyer. And I will reiterate once again that there are some great consultants out there. There really are. But there are so many shady ones that you really, really have to be careful. And, although the consultants will constantly say there's shady lawyers, you bet there are. To say that the ranks of immigration lawyers is perfect is totally not the case. In fact, if you go back probably about a month ago, I did a special episode on one of our lawyers who was a Canadian Bar Association member who got himself into a whole host of problems with clients and mismanagement of funds. And it was really embarrassing. I hate seeing my fellow lawyers get themselves into these issues. But I can tell you, the Law Society's come down like a hammer. And, and I am fully supportive in every way of any lawyer who's practicing unethically or obviously unlawfully in any way, that the full weight of the Law Society should be thrown at them and they should be removed from the bar and be unable to practice law. That's my position. But I just, the Consultant Association is taking some steps now to try to clean things up. I hope it works. Like I genuinely hope it works. But, there's just so much exposure for people who just don't know otherwise, and the protection of the public, despite this belief that, us immigration lawyers are trying to protect our turf. That's not the case. It really, really is about you. And so be advised and be wary. Okay. Let's see here if there's any other questions that relate. Okay, so here's one from Tricia. And she says, hey, Mark, how about Quebec's Arima Portal? No news yet if they are processing or giving out nominations.
Right. So that was what I was talking about, where you need the crystal ball. So the only people who seem to be getting invitations in Arima, and for those who don't know, that's sort of our little express entry equivalent, are people who have validated job offers. And you also have to meet sort of point requirements as you would in the federal skilled worker program. Nobody else is. Things are kind of in stasis right now because of COVID. Maybe because they haven't really made up their mind what to do. They have a little bit of a numbers problem here in Quebec. Yep. We have a government committed to a certain fairly low level of new immigrants. We have a lot of people who are qualifying in the Quebec Experience program. That leaves limited space for other skilled workers. Right. I think they're still trying to figure out how to deal with that issue.
You bet. All right. Well, that's a great question. Thank you for addressing that. Okay, so let's see here. Katie says a thank you here for answering her question. So you're very welcome. And we've also got another thank you. We appreciate those. Okay, so here's an interesting question, David. So this individual says, if my representative is listed in CIC website, does it mean they are real lawyers?
First of all, I got to ask what CIC website they're looking at. I would love to have the URL for that, because CIC website doesn't list lawyers.
Yeah,
CBA one does.
Yeah.
The Provincial Law Society websites do. The consultants have their own listings, but the CIC does not list lawyers.
No, and I think probably what this individual is referring to is that their consultant is on and you can see all the acronyms, CIC, ICCRC, you can get really confused by it. But basically, I think what they're asking is if their agent or their representative is listed probably on the ICCRC site, does that mean they're real lawyers? And the answer is no, they're not. But they are authorized.
They're real consultants. Yeah.
Yeah, they're regulated consultants, and they're authorized to represent you before the government. So for sure,
we should mention actually this, and this is maybe important given our topic today, that consultants in Quebec need a separate accreditation with the province in addition to the ICCRC. So they have their own accreditation with the government of Quebec, and then government of Quebec has a website where they list those consultants who are licensed to represent people in front of the government of Quebec. So it doesn't mean necessarily if someone's in Quebec that they absolutely need a Quebec. If they're doing, let's say, an LMIA exempt work permit application that doesn't involve Quebec, that's fine. You don't need the Quebec accreditation. But the minute anything is going into the government of Quebec, you need that accreditation.
Good point. Thank you, David. Absolutely. Many provinces have separate rules, obviously, with respect to, especially within the provincial nominee programs, and sometimes there are added requirements that are a part of that. So you have to be educated. Okay, this one is an interesting one here, and I'm going to teach you something here, David. So when I get one of these questions, I typically will do this, which is a little ding, and that means that this is really legal advice. I'll read the question just so that we can see. But Justin says, hey, Mark and David, in my application, I've mentioned about 2 weeks of travel history to the U.S. in the travel history placeholder, and the same is not mentioned in the address history. Will this be a misrep? Now, I ring this bell because really there's a whole lot more involved here, and neither David nor I want to provide legal advice to any one person about their own specific circumstances. You really need to go and book a consult. But what I can tell you, and I think as we address this generally speaking, I always take the position that if I have a location listed as my address where I live, I don't also duplicate that as a travel history in my express entry, my EAPRs. So if I am from India and I traveled to Canada to go to school for a year, I don't list that as in my travel history as 1 year of travel history. If it's in my address history, I don't list that as travel. I do list any little trips outside of a place where I live as travel, and that's how I address it. I don't know, David, if you have another question or if you,
right.
If you see
I
them
begin
answering.
From what is residence. So that's where I habitually live. That's where I've got my clothes and my belongings. And if I go to another place and I stay in a hotel there, that sounds a lot like travel, but it doesn't sound like a residence.
Yeah, perfect. Okay, great question. Okay, and I think we're just about at the end here. Let's see here. Some people, those of you who are asking questions just generally about general immigration stuff, I'm kind of bypassing those and I'm focusing just on the ones with Quebec. We've got just a few more minutes. David's been very gracious with his time here, and I'm going to try to keep it to an hour here. But let's see, we've got another question. Let's see. Okay, so this one's from Amarjat, and it says, somebody who became a PR under Quebec, under the skilled class, can they leave Quebec for Ontario? And if yes, in how many days? Oh,
okay.
I get this one all the time.
I think you need to ring the bell again.
This one. Yeah, okay. I'm gonna ring this one. And David, maybe you can just address this question generally, not specific advice to Amarjat, but just some of the legal ramifications at play here.
So the legal notion that we're working on is on the date that the person became a permanent resident. This is whether they are living, inside or outside Quebec, depending on where they're supposed to be at that time or not. Was it their intention to live in the place that they're supposed to live in this scenario in Quebec? So if a person, just as an example, was doing a 1-year contract outside of Quebec and had sublet their apartment, and it was clear that when their year was up, they were coming back, it would be very hard, I think, for the department to say that they didn't have the required intent But it really is fact specific.
It is.
And intent is always hard to prove. It's always a touchy thing. It's also, frankly, what protects a lot of people. It's why, CBSA doesn't go after a lot of people when they're not in the part of Canada that they're supposed to be in, because it's hard to prove on that particular date and time what was their exact intent. But, if you're cavalier about it, if you never live in Quebec, and there's no indication that you ever had the intention to go to Quebec, that gets caught. For example, when you apply for citizenship, suddenly you're getting called in to meet with a CBSA officer, you have an interview, you have a problem potentially. If you got, that it was easier to do Quebec, so I did that. That's not going to play well.
No. And that same principle applies equally with the PNP nominations. So when you must demonstrate an intention to actually reside in that province. And so when people are nominated, and this is my pet peeve, David, because I see so many thousands of people who would do anything to get a nomination from, Prince Edward Island or Saskatchewan, right? And then you have people who use that but have no intention of ever living there. They just plan on heading out to Ontario, to Vancouver, British Columbia, and they have no intention of actually residing in the province, but they're just using it. I personally hate it, because the whole reason those programs exist is to encourage people to take their skills, their talents, all the amazing abilities they have to come and make that province better. They've shown so much faith in you that the federal program had no faith in. Well, I shouldn't say faith, but you just didn't meet the qualifications. But the province shows a faith that, hey, if we give you this nomination, will you actually live here? So that's my pet peeve. And so whenever people ask me this, yes, intention, when you reside, there is nothing that binds you to staying in there, for any particular period of time. It all comes down to the intention. But yeah, when I'm giving advice to people, my only advice to them is stay, make it work. Find a way. If you reach a stage where you literally can't provide for your family, you can't find a job, you're just struggling to the point where it's just, it's just not going to work out, then yeah, the charter allows people freedom of mobility. But my goodness, that is so far down the road when I look at it. That's the advice I give people.
Well, I would say conversely, if you're selected by a province and you're working away there, and a headhunter approaches you and gives you a dream job possibility, happens to be another province, well, there's nothing wrong with you taking that. When you became a permanent resident, your intent was in line with the law, yep. And it changed later on. You're allowed to do that.
You bet.
But good faith is important.
Absolutely. Okay, I am going to pull up one last question from Alician, and the question here is it's kind of borderline legal advice, but I think it's generic enough that we can apply it to everybody.
Very soft bell?
Yeah, it's a soft bell. Yeah, it's maybe it's this one here. Okay. So Alician says, "Hey Mark, I have a student visa refusal from Australia. Will that affect my Canada application, and which part of the application am I expected to reveal that information?" So what we'll do is we'll take this and we'll put it in the context of express entry. Every type of application, it kind of pops up in different locations when you're submitting your applications. But for the purposes of express entry, which is probably what you're looking at here, it shows up in the statutory information section. And the question really comes down to, will that affect my application? Well, it will, my friend, if you don't disclose it, right? That's where it's going to be an issue. But there's this...
Yeah, especially from Australia.
Exactly, where Canada has information sharing, and they have the ability to look right in and get access to your Australian immigration history if they choose to request it. But the key here is that there's this misconception, and this is where lots of people fall into this, this misrep trap, is they believe that somehow a temporary visa refusal, an application to go visit or study in a different country, is going to be negatively treated, or it's gonna somehow negatively affect your eligibility for express entry. And David, is that the case?
Yes. I mean, if you misrepresent.
Yeah. If you don't disclose it, but I'm saying if you disclose it and you tell them.
If you disclose it, well, I mean, that depends. What we don't know is why was the application refused.
Yes.
And that will be very relevant. And there's generally a space for someone to explain. Yeah. And might be a good idea to explain if it was you didn't have a document in time that they were asking for. probably not so bad.
Yeah.
If you misrepresented, that's likely to be worse.
Yeah, exactly. And that's really what it comes down to. So that's the part when we're saying, when you're asking us specifically, Alishan, this is where we will ring the bell and we'll say, look, we need a whole lot more information. But one thing I want to tell people, regardless, it doesn't matter what the issue is, you must answer those questions truthfully. And the advantage to express entry is you've got this big, large section at the end called a letter of explanation. So in the context of answering the question, you answer it truthfully. Yes, I had a study permit refusal in Australia. This is when it happened. And your letter of explanation can go into a lot more detail if you feel like you need to provide it. And you know, the one thing I just want to disabuse this notion that somehow that just the simple fact that you've been refused a visitor visa to go somewhere, you know, maybe they didn't believe that you would return back. So, you know, that you couldn't demonstrate, you know, that you had ties to your home country or whatever it is, right? Those types of things do not, just because they happen, negatively impact on your express entry application. It depends on the context, but generally speaking, it's not going to be an issue. Disclose, disclose, disclose.
Right. The consequences of disclosing are almost never going to be worse than the consequences of misrepresenting.
Absolutely. I agree. Well, this is great. Well, thank you so much, David. It has been just an awesome, awesome time connecting with you. And so what I want to do right now as we wrap this up, and I want to thank everybody who's watched, who's been participating with us here. It's fantastic to have you join us. We're going to flip over here and I'm going to show you guys where to find David. And so I'm going to pull up right here. This is David's website. Now, David, they can't hear you right now, but I'm just going to pull up the website and then I'll pull you back on. So this is Chalk Immigration. This is David's website. And you can go right here and you can get all the information you need. You can see there's a contact us button right here that you can click over in the top right corner, and it will give you the ability to see where his office is located, and you can fill out the contact us information and you can connect with David, and he's, then we'll be able to give you direction and advice on whether or not that you guys are a great fit and whether or not he can assist you. So I highly encourage you to go and check that out. And David, is there a better place, or is there, a better way that you would like people to reach out to other than the contact us on your website, which obviously has your phone number?
My email, my cell phone, my telephone number. I think one of those ought to do it for people.
Perfect. And all of that is right on the website that you guys can see. And I'm actually going to just flip back one more time to David's page here. And so you can see his team is all on the front. And it's not just David. He's got a great team around him that, that they can handle all of your Quebec-based immigration and Canadian immigration, regardless, everything that you guys would need assistance with. So that's my pleasure. I get to plug these awesome people who come on and take the time to share their knowledge and experience. And you can clearly see that David is highly, highly experienced in Canadian immigration law and just an awesome guy generally. So. Anything
Very
you want to
kind
add?
of you, Mark. I'm so thrilled that I got to be your first guest on Immigration Nation. I'm going to apologize for everybody who thought that this was going to be a ride along with ICE in the U.S. Having seen the Netflix series, but I hope that we've offered something interesting and useful all the same.
You bet. We're transforming it. What David's referring to is this Netflix show with the enforcement that they go through in the U.S. and with ICE, and we're definitely taking a different spin for sure.
We're not telling you how to arrest people in their homes without a warrant, which is what you would learn watching television series.
No, we're telling you what to do if that does happen. And we're going to bring on other immigration lawyers that are fantastic, that have expertise in different areas, to just pull back the curtain on what we do. Now, the last thing...
Mark, thank you for what you do. I know I speak for many, many immigration lawyers who follow your podcast first, and now what you're doing on other platforms, and you help all of us be better lawyers.
Awesome. My pleasure, David. It's been great. Okay, guys. Well, this is Mark Holthe and my first special guest on Immigration Nation, David Chalk, saying thanks for tuning in, and it was great. Come back again next Wednesday, probably around the right time, the same time as this. We'll see how it plays out. We started this one about 11:15 a.m. Mountain Time, but it could be a little bit later, but it'll be here on Wednesday, and you can always watch this as a recording as well if you came on late and you want to get some other information about the two topics we talked about, Quebec immigration and misrepresentation. All right, thanks, David.
Thank you, Mark. Have a great day.
You bet. Take care.